Here in the appeal of Hawkins against Abarbanel Limited.
Now, as you can see, there are 4 members of the court here in person, and the 5th member, Dame Janice, is joining us online. Mr. Rule.
My Lord, I appear on behalf of the appellant, Mr. Hawkins, along with my learned friends, Mr. Merrin and Mr. Amin, and my learned friend, Mr. Brown, appears on behalf of the respondent. As the court knows, we appeal respectfully with permission, with leave of the board, humbly advising His Majesty, from 2 judgments of the Court of Appeal in the Cayman Islands, the first of which, the substantive appeal dismissed on the 11th of January 2024, which was an appeal dismissed against a judgment at first instance, refusing to grant declaratory and other relief sought by the appellant in relation to a enforceability of a contract and a charge that he'd entered into with the respondent. That decision itself, the Grand Court decision, was by the Honourable Justice Ramsey Hale on the 16th of December 2022. Now, I propose, if I may, to follow this course, firstly to deal with Ground 1, giving an overview of the appellant's submissions on Ground 1, then turn a little bit more detail to the key facts that we emphasise and the factual findings below, in light of the pleaded case below, then turn to the statutes themselves, the TBLA, if I may use the shorthand, the Trade and Business Licensing Act, and the Local Companies Control Act, LCCA, and look at, firstly, the illegality that those create, and look at the purpose that the statutory regimes indicate those regimes pursue. After that, I'll deal with the Section 23 interpretation specifically, moving on to common law illegality case law, starting, of course, prior to Patel and Mirza, but spending more of my time, limited as it is, on Patel and Mirza and the cases that have followed, explaining where we are in relation to common law illegality. Then I look at the SO decisions upon which the respondent and the courts below seek to place reliance, and the decisions of the Grand Court and the Court of Appeal in this case. I deal then with an issue of knowledge, which is raised by the respondent, and will seek to differentiate knowledge of facts and knowledge of law as 2 very different matters. And then, summing up, I'll present our submissions on the application of the Patel and Mirza trio of considerations in this case, bearing in mind, of course, it's not at year 0, and there are principles that are found within it that emanate from earlier decisions and common law principle. Within that ground, still with Ground 1, I'll mention, of course, the relevance of the Proceeds of Crime Act, criminal proceedings or criminal law, so that it, of course, informs the relevance of the integrity of the system of justice as a whole, which is one of the key factors or the key rationale behind the doctrine of illegality, as we would submit it is formulated in Patel and Mirza. From Ground 1, I'll move to Ground 3, dealing with what were the POCA issues in the proceedings below, and then dealing with the POCA law, 3 particular parts that we've drawn attention to in our case, which we submit are relevant and inform that Ground 1 POCA relevance, the Process of Crime Act, POCA, and the case law briefly that the English jurisprudence provides on cases of benefit from criminal conduct, where there are licensing offences as the nature of the illegality. And finally, as far as time permits me, the permission to appeal point, the second judgment of the Court of Appeal below, and the point of law we respectfully raise as to whether or not it properly applied the test that is applicable to an appeal that lay as of right.
When you do come on to the POCA points, you'll need at the outset to address us on whether you should be permitted to develop an argument on that in this court.
My Lord, in relation to POCA, I think you mentioned.
Yes, obviously there's an objection.
Yes.
You on that.
I'm not going to take things out of order in that way, but I can just say that we with respect, find the respondent's case to be aimed at the wrong target. It's not the POCA case we set up at all. So I think it will go hand in hand with what is my case on POCA relevance, and whether it's a matter that this court can properly and fairly take into account isn't prejudicial to the defendant, the respondent, in order to evaluate the legal ramifications of enforcement of an illegal action that would be the result of any enforcement of the civil claim that Abarbanel, the respondent, might bring. So I go back to the start of that list, as long as it was. The submissions that we make in summary on ground one, we start firstly with the unappealed findings of fact. The respondent was carrying on business in the islands, doing so without a licence under either the TBLA or the LCCA. In each case, in both cases, that was a breach of the legal requirements under the Act and a criminal offence under the Act. The offences are referred to in the first instance judgment. They are strict liability, and they simply follow from carrying on business without a licence. That was the factual findings that had to be made in the dispute between the parties. It was framed as illegality, and it means offences under this Act. That is the respondent's actions. On the other hand, you have the appellant's actions. He did not aid or abet that illegality. On the findings, he was not aware of the facts that render the respondent's conduct illegal. The only party who was aware of the relevant facts of the illegality was the respondent. He is therefore properly construed as the innocent party to the illegality and the transactions that flow from that illegal carrying out of business. Second point, the TBLA, of course, makes no provision at all for the consequences of that illegality. Thirdly, the limited provision that the LCCA makes as to consequences is focused upon one particular target, which is that not automatically, in all circumstances, shall an arrangement be rendered void or voidable only by reason of the breach of the law at the relevant time. We'll come to the exact wording, of course. But what we say is about that provision, it is very clearly aimed at what is a long-standing, and we take issue with the respondent on this, a long-standing understanding. There is a difference between a void contract, to use unenforceable by either party, but void in the traditional language, or unenforceable by reason of common law illegality on the part of the illegal offender. So that recognised distinction between void or voidable and unenforceable, on the other hand, is one which Section 23 of the LCCA respects. And it demonstrates the intention of Parliament in relation to that Act was not that all contracts should be automatically void and unable to be acted upon by an innocent party. But we take issue with the respondents, I'll elaborate upon, in suggesting that one can infer Parliament's intention, and one must infer from the statutory language they meant something else. That they meant that it would be enforceable in all circumstances. We submit neither of those binary positions is tenable on the proper construction of the legislation. Fourthly, the formation of the contract or the charge is not statutorily forbidden. The board will be aware that we have abandoned any suggestion that implicitly within the statute one can find an intention of Parliament that there should be a consequence, that there be a void effect to the contract or to the charge based on the breach of the law. We accept it's not express, and we accept it's not clearly implied either. But we do not accept that it is implied in the other direction, that there is to be read into it that in all cases, irrespective of circumstances, a contract is to be enforceable. It could have been clearly stated. It isn't clearly stated because it's not the intention. It is sought a very different intention to exclude common law principles of illegality entirely and principles that have been developed. Another to say that we don't automatically prevent a court looking at it. We don't automatically say that it is to be enforceable in every case or unenforceable in every case.
So you're drawing a sharp distinction between void or voidable on the one hand and unenforceable on the other.
Yes.
I mean, as against you, it might be said, well, in the area of illegality, it's often been interchangeably used. The words void or unenforceable, you'll find interchangeably used. So is it not somewhat unlikely that such an important distinction would have been made just by using the words void or voidable? Don't they, in other words, include unenforceable?
Well, my Lord, the fact that they have not always been clearly differentiated is no doubt accurate. However, what we do submit is that their meaning has always existed as something different. One has to now analyse the earlier cases through the prism that we now recognise illegality is defined as either statutory illegality or common law illegality, the latter including all the principles and public policy objectives, the former including an attempt to construe a statute and any implicit meaning that it must have to avoid absurdity or to avoid the unworkable nature of the statutory provisions. Now, what we say about when this Act was enacted, and it has been reenacted in the same terms many times since, is deliberately choosing void or voidable removes the ability to have an automatic situation or an elected situation where the contract is only by reason of the breach void or voidable. But what wasn't said, and it is a term that could have been seen in the case law at the time, is that there shall be unenforceable or shall be enforceable the contract as a result. Of course, to say it was unenforceable would be essentially the same thing as saying it's void, has no effect, there can be no rights created by it. But unenforceable has a wider meaning which the courts have used. Now, even though sometimes they were not differentiating at the time between statutory or common law illegality, they were moving on from this statute doesn't impliedly prohibit the contract, so it does create rights. We now consider on public policy reasons, ex turpi causa or other profiting from the crime, other principles that have arisen, we consider one party alone can enforce and one cannot. And the court spoke there not of void, but of it being not void, but unenforceable by the one who was guilty of the illegality, as opposed to the both. Well, I accept unenforceable by both, if a statute said that, would amount to void in a different way, because it would mean that there is no ability of either party to enforce the contract. Void perhaps is a term that clearly indicates that no rights have arisen. Unenforceable might be a different concept in some ways. What we do say is what is very clear is that had Parliament in 1971 wanted to say in all cases it's enforceable, or in no cases is it unenforceable as a result of this, it could have done so, and it would have done so. Because the concept of ousting common law jurisprudence on principles of fairness or of justice in the illegality doctrine, that's one intention. To oust that is a very serious intention, and not one for which the respondent can point to any support as to why Parliament would have that intention. But in all cases, the court has nothing to say about an illegal act. Rather,
but if the statute had said void, voidable, it's shown not in these circumstances, in any circumstances make the contract void, voidable, or unenforceable, would you accept that that's the end of your case?
If the statutory provisions said that you had to, ousted common law unenforceable option, then there would be no ability for the common law, in my respectful submission, to go behind the statute. If the statute clearly ousts its jurisdiction, it must follow that the courts would respect Parliament's will to oust its jurisdiction. The fact that Parliament would oust the court's jurisdiction over illegality would be such a surprising result. It tells against the submission that that's what Parliament must have intended. There's no absurdity, of course, to using the words void or voidable. They very clearly mean that the court will have jurisdiction to decide on the issue rather than the statute deciding it. And automatically, by reason of the breach, you cannot rely on the contract. And we have the uncertainty and the automatic provisions despite circumstances.
So what I'm putting to you is, if we just look at the terms of the statute, sorry, I may be taking you out of your order, but I just want to be clear what you're saying. It says at the moment, section 23, no business transaction shall be void or voidable by reason only, etc. I'm suggesting to you, if it had said no business transaction shall be void or voidable or unenforceable, that would be the end of your case, would it? You would accept that?
Yes. The common law result of an illegality offence must be that the right created is unenforceable. And if the statute has excluded that outcome, I would concede that there's no way round that for the court. The court would be absolutely hamstrung.
Yes, the key to your case is that it says void and voidable, but doesn't say unenforceable.
Precisely. And of course, that is my case only on one statute, because the other says absolutely nothing about it, which is again inconsistent with Parliament being absolutely wedded to the idea illegality doesn't matter under this regime. My Lord, I will come back to section 23. If I can return just to the summary of our submissions as a whole, I appreciate it's a very important topic, so I'll come back to that in a little bit more detail if I may subsequently. Returning to where I was in the overview, as it were, we respectfully submit that the consideration of the public policy considerations and the equitable principles left to the courts to determine the enforceability of the contract by one or other party. And that brings us to the application of the Patel and Mirza trio. We place significant reliance on that, of course, as it represents the current law. But we also rely, with the benefit of dicta in various cases that have followed Patel and Mirza, on principles of long-standing which are consistent, and decisions which are consistent with the application of the trio, so that there is unenforceability in the profiteering, and we are concerned with interest claims, from someone's own criminal conduct. So first principle that survives, clearly given effect through those trio of principles, a trio of considerations rather, is the principle a person should not profit from his own criminal act. The second principle which it's consistent with and gives effect to is the consistency and coherence within the law. We submit these two factors are, as Lord Kerr and others make clear in Patel and Mirza, the original justification for the ex turpi causa maxim, or merita acto maxim. The third principle, so those are two, not profiting from your own criminal act and consistency and coherence with the law. The third principle is that reliance being placed on one's own illegal act is a relevant factor. It might be termed in the centrality of the claim, or it might be termed to go to the undermining or otherwise of a regime. But the reliance one has to plead on one's own illegal act in order to enforce remains a relevant factor. Not the test for illegality, of course, but remains relevant. Fourthly, that distinction between enforceability by an innocent party and the offending party, consistent with principles of non in pari delicto or not being equally at fault. Fifthly, we mentioned public policy concerns with money lending. Long-standing principles over where risks should lie if someone undertakes money lending. The law has drawn a distinction between contracts which are of public utility, such as insurance, or otherwise the risk falls on the innocent party if the broker didn't have the relevant authority, regulatory permissions. Very different treatment of money lending, because the courts recognise the burden and the risk goes on to the innocent borrower because of the illegal acts profiteering by the lender, unlicensed money lender. We sixthly rely on the difficulty of specific performance compelling an offence to be committed. The reasons that we address, that is a consequence of what Abarbanel would wish the court in its civil jurisdiction to grant it, compelling of an offence for specific performance, carrying on a business on its part and the assisting of an offence under POCA by the and aiding the offences under the Licensing Act by the appellant. And we finally, under this summary, come to the freedom to contract and consenting parties does not require a contrary conclusion. We accept it's a factor militating in the other balance, as it were. But it doesn't trump all the policy considerations that illegality considers and the principles it considers. If it did, of course, no illegality would ever matter, if condoned by both parties anyway with knowledge, which this is not. But the freedom is really only the appellant's, because he is the innocent party, and he is not seeking to rely upon the contract. The respondent, on the other hand, is not free to contract illegally. The law specifically removes its right, if it had any, to conduct this business. It's carrying on business illegally. There's no right or freedom to do so where statute takes that away.
Could I, Mr. Rule, just ask you about the actual offence itself at page 855? Because you say it removes the ability to enforce the contract. That's 4.1b. At the relevant time is carrying on such business in accordance with the terms and conditions imposed in such license, and not otherwise. So it's an offence. Would it be an offence if any of the license conditions was breached, no matter how trivial?
Yes.
And you say that that would lead to illegality?
Yes. And the triviality would be a matter that the court can take into account in a proportionality exercise, having considered the competing public policy considerations about enforcing the law. And I should point out, this is the 1971 version, but I think my Lord's right, there's no difference in this statutory provision as it's drawn in section 4.2 at that point and materially with the 2007 Act. So we say that for all of those reasons I've already advanced, when we come to apply the trio, we'll see how the balance favours. And I'll deal with the proportionality issue in this case. You're talking about huge sums of money made by illegal activity. And the proportionality is not to be equated with minor breaches, which have no impact on the parties' actual positions. But more importantly, of course, we're not dealing with a doctrine that is about justice between the parties. That's been the problem with it in the past. The doctrine, whilst it seeks to do justice, applies public policy for the reasons of the statutory regime and for the reasons that the court will not have the integrity of the system of justice undermined by enforcing illegality. And so it's never been a policy that is based on simple decisions of equity between parties or allowing individuals to act illegally if it doesn't seem to be particularly serious. The basis of it is proportionality as a check. It is not a consideration as to where illegality takes us in public policy, because the public policies are much wider and more important than the individuals. So I'll come back to those when I deal with my case on the Tellermers in detail. But we say that the seventh point of opening the submission on ground one is the integrity of the system of justice requires the consistency and congruity between the civil and the criminal law. The purpose of the statutes is advanced. Now, I'll deal with the difference as to what the purpose really is of the statutes, but even if it is about controlling business to protect the local population in the public interest, that is a public interest purpose, which is undermined by those who undertake business, undercutting or dealing in a way that businesses that are licensed are unable to do by operating illegally in the islands. And POCA is relevant in three ways to that integrity and that congruity, which is the rationale and purpose of the illegality doctrine. Firstly, the consistency that the proceeds of crime should be confiscated. Now, under that part of POCA, one requires prosecution and criminal court order of confiscation. But its purpose, consistent with illegality in the civil law, is to prevent profiting from criminal conduct. Second and third parts of POCA, to which I'll make reference, if permitted, are the DPP's ability to issue civil proceedings for recovery. Although Proceeds of Crime Act is probably correctly described as a criminal statute, it is in part concerned with the civil recovery of what are the proceeds of criminal conduct. And the civil law of illegality will clearly wish to be consistent with what statute Parliament has enacted with its intention that a person who's benefited from their crime should have that available to the state to recover and to make available to the loser. And the third element is the money laundering offences that POCA creates, which the appellant would be obliged to commit if required to pay money to the criminal, illegal operator, respondent. And by way of proportionality check, which I'll come to as the final of those considerations for the cross-check, it would be, we respectfully submit, absurd to allow the respondent to profit by interest of over $1 million from its own entirely illegal operation. Completely contrary to a regime that should have controlled and regulated its ability to do so. A board would have taken a decision whether it was in the public interest, have it operating and doing so in the terms and under the conditions that it did. It has had, there's no unjust enrichment because it's had back the principal sum. None of our submissions are inconsistent with, had it not been voluntarily given, an unjust enrichment claim lying to ensure that there is essentially placing back of parties into the position had there not been the illegality rather than a profit to one or the other. And that's one of the benefits, of course, of not having voidability but unenforceability in the contractual situation.
You say that the license would allow the authorities to regulate the way that the respondent carries on business. I think that's your submission, is that right?
Yes, within the legislation it allows conditions and terms to be placed on a licence.
Yes. Is there any evidence that the conditions and terms imposed on, in licences under the LCCA have sought to regulate money lending, for example, as distinct from the requirement that the business have a certain presence in the Cayman Islands and an office and things like that?
My Lord, there's no evidence before the court either way about the operation of the boards or the licences. What we have by way of evidence is that the respondent has never held a licence, has never operated lawfully with a licence being granted on any particular terms. And we can compare that to ESSO, where there was a licence, it expired, and a retrospective licence was granted again. By the time the court was dealing with the case, they'd already regulated their position. They'd obtained from the board empowered to give it, considering all the considerations in the statute that the board would have to consider, it provided it with the licence that it required to have acted lawfully, with retrospective effect. Now, the difference here is that the board is not assisted by Abarbanel being able to show it ever was licensed or was properly to be licensed, because it never attempted to obtain one. It hasn't attempted to obtain one, notably, since the matter proceeded. It knows it could obtain a retrospective one if it thinks it's a fit and proper company to be licensed. But we fall back on the absence of evidence. All we have is that it's never been licensed, so no indication it is worthy of licence. But we have to fall back on the statutory provisions which provide particular public interest factors to the board to consider in deciding whether to license and what conditions to license under.
This is you're founding on the amendments that came into Section 11.4.
Section 11.4, yes. In terms of the statutory provision as it stood, that has to be the basis on which I make the submission about what were the factors of public interest relevant to a decision on licensing. There's a slight complication to that in that the Act has gone on in its 2021 revision, which was enforced before the proceedings below, of course, made decisions, but not at the time of the original contracting and charge. But that provision has added in the questions over anti-money laundering compliance and other factors into the TBLA legislation. Part of the importance of regulating the financial industry in an island which is founded economically on the integrity of that system. So what one can see in the 2021 version of the Act is very express references now to you have to be complying with anything that applies to you as a financial institution or lender under the provisions. Now, there is in the pleadings below reference to this within HOCA as well, which mentions it in Schedule 6 and a particular section, Section 2, I think. There's a monetary authority which also is triggered in and becomes part of it. But I accept that in terms of statutory background, one has the 2007 Acts for this arrangement going into. But in terms of public policy considerations, my responsibility in the court can have regard to the licensing regime being part of the Cayman Islands' attempt to regulate its financial industry. And contrary to what was said, I think, in the respondent's case about the CIMA, the monetary authority, only coming into existence in either the 90s, there was a 1966 Act for banking regulation. It wasn't the beginning of any attempt to regulate financial industries. But I make only a small point about the 2021 amendments, perhaps augmenting the public interest factors in a specific way to the concerns over financial lending. But you have the general public interest factors already set out in some detail by the Act. So we rely on that as the intention of Parliament as to what the Act intends by way of its achieving by way of purpose, and what the board would consider as relevant factors, and whether or not to
Could I just understand the point that you're making? As I understand, under common law illegality, if Section 23 is to be properly construed as unenforceable, including unenforceable, that's the end of the case. Under common law illegality, you don't get to the three Patel v. Mercer points. So, in one way, Section 23 is the first issue to be decided. Then, on your what was your, I think, third ground of appeal is now issue 2. The issue there will be whether it was raised at all in the pleadings before the court and so on. But don't we really have to deal with Section 23 first?
Well, my lord, certainly happy to move to Section 23.
Well, I mean, I'm not asking.
We make a number of points about Section 23, but can I perhaps just go to the Act and deal with the Act, and I'll come to Section 23 within the Act, so that I'm not just taking it out of course. The TBLA first.
Can I just before we move on from that, my understanding is that the Court of Appeal in this case, relying on the ESSO case, had very clear views about what the purpose of the licensing regime that we are now dealing with was. Are you challenging those analyses of the purposes?
We say they don't go far enough. We say there are other purposes that can be ordained from the legislation, which should be ordained from the legislation, which they don't refer to.
And that's your public policy argument. You say amendments have brought in further considerations since ESSO into the licensing regime.
Indeed. We say you can't read Section 11.4 and all of the subsections specifically inserted by Parliament as considerations as if they in some way don't reflect a public policy or public interests behind the regime. And so we don't say it's not enough, in fact, that if you've got a regime intended to control the operation of foreign businesses, that's a public interest. If you've got a regime that raises revenue, that's a public interest. We don't say they're irrelevant to founding common law illegality. We say really the difficulty with the court below's judgments are both seem to operate on the basis that if there's no statutory intention to render the contracts void or voidable, that essentially leaves the court without the need to go on to consider in any detail the factors under common law illegality. So it remained wedded to a statutory construction attempt based on statutory illegality and doesn't really engage with the public policy issues in a way that's directly focused on the trio of considerations. They rather deal with it, which is perfectly proper, of course, looking at the purpose of the statute to decide whether a provision is absurd, whether it doesn't give effect to the statute. Those matters, of course, the court will have regard to a purpose of a statute, but it's for a very different purpose, and the purpose there, the courts would have understood, would be to render a contract void, and in doing so, remove any judicial control, and automatically create uncertainty in every contract, even if the innocent party didn't want the contract not to be enforceable.
I sort of understood that the Court of Appeal were in effect saying, well, the purposes of this legislation are not designed to protect the other party to a money lending transaction. They are purposes designed at a rather higher level to keep out foreign businesses and actually as a means of raising revenue. They weren't protecting individuals in transactions at all, as I understood the Court of Appeal, and I think they were drawing on the Esso case for that. Now, you're saying, as I understand it, that that's just incorrect, that in fact there were, at this time, other policies in place.
There are other policies in place, and although one's not directly concerned with the two parties, one's concerned with the purposes of the statute in public policy terms and the effects of illegality undermining those public policy objectives, including those which might have benefited one party, the innocent Mr. Hawkins. But that's not the focus. The focus is on the purposes of the statute being given effect through the doctrine of illegality, deciding whether or not to enforce, because those purposes are met or not met in a better way by enforcement or otherwise, once you consider all of the proper policy considerations, factors that go into that.
But what I mean to say is, if you go back to money lending statutes, let's say, in the UK, the policy often was to stop unscrupulous money lenders, and therefore taking advantage of individuals. That, you could say, was the overall policy. Now, as I understand it, that is not what the Court of Appeal regarded as the underlying policy here. It was something rather different, which obviously is important when you're looking at the effect on a contract.
Yes, the Money Lending Acts, of course, rendered illegal the action of money lending and were void. Yeah. So the consequences were statutory illegality consequences, we say. Yeah. Void. The statute prohibits you, we cannot give effect to it. And there are examples, of course, where that operates harshly to an innocent party and not harshly to an innocent party. So the reason we now have the more developed understanding, we respectfully submit, of illegality is that statutory illegality, unless one has a statute expressly dealing with ousting common law illegality, which I accept can be the case, if one doesn't have that, which would be an unusual case we submit, one then falls back to, well, the courts no longer want to be bound in a case where the justice isn't followed by a money lending agreement being void, even if it's prejudicing the innocent party. So we have the ability, and that's a bad example because the Money Lending Acts may still require to be void. They may still require on their construction to render a contract void. But in our case, we are not dealing with a void contract, we respectfully submit. We're dealing with whether or not the court would give effect to the illegal activity, condone and enforce the illegality or not. And it does so on a much more nuanced, individually considered basis because it is entitled to do so, we submit, under the legislation. Now, I was invited to go past the judicial findings, as it were, to the statute, and I'm happy to do that. Maybe that seems to be of interest. So if I do that, could I start, though, with not Section 23, because we have an Act which Section 23 can't have anything to say about in the form of the TBLA 2007, which was equally violated, and equally a breach of is an offence. So the first element to that, and it begins 2007 TBLA on page 1145. I don't ask the court to go there yet, but that's where it begins. The first thing that was looked at is the Memorandum of Objects and Reasons. Court of Appeal below said it's only of historical relevance because it dates back to 1971, but you have the essential working of this Act, as the court knows, is to require an annual licence to be held by any non-exempt businesses and carry that forward. The historical relevance on our page 62, tab 7 of the key documents, it's within paragraph 11 of the Court of Appeal's judgment, is to protect existing businesses. So that was a generality, and I accept, in terms of statutory construction, I don't intend to spend a huge amount of time on that because the court will have well in mind the principles, but the generality of the Memorandum of Object, of course, gives way to the specifics, but the generality applicable, that it's to protect existing businesses. Existing businesses may not be the appellant, but they are there for protection from rogue operators coming in and doing what they shouldn't be doing because they don't have the licence that the legitimate businesses have.
Sorry, you're talking about the Trade and Business Licensing Law of 1971?
Yes, TBLA 1971 had the
Memorandum of Objects and Reasons we have on page 1144.
yes.
And it explains that this law, the 1971 law, appeals the equivalent law of 1955, the main object of which was to protect existing businesses. It goes on in the next paragraph to tell us that protection of Caymanian businesses from persons of non-Caymanian status is now adequately safeguarded under a different law. And it says, and the function of the trade and business licensing law is to raise a certain amount of revenue. In relevant cases, which wouldn't be our one, to exercise hygienic control over premises.
Yes.
So it's a revenue-raising statute. At least that's what the Memorandum of Objects tells us.
My Lord, it is a revenue-raising statute in that sense, but one also has to move from the general to what it then achieves because it happens to exist and what is it used for. So from 1971 it hasn't remained unaltered in terms of what it is used for, and so the board is created by section 4. Section 12 requires the annual licence on 1151.
Sorry, the page number again, please.
1151, my lord, is the person shall take out an annual licence, section 12. And then the licence is granted, section 16, the next page, 1152. Unless subsection 1E, 16(1)(e), the applicant is a company that requires a licence under the LCCA and is not the holder of such a licence. So you cannot be granted it. There's no way that the respondent could be granted this licence because it doesn't hold the other. Subsection 2, the board may attach such conditions or restrictions to a licence as it may deem fit. There can also be forfeiture of a licence under section 22, but I don't need to see that. Section 26.
Yes, where it speaks about the board issuing conditions, its power to issue conditions would be determined by the purpose of the statute. It can't issue conditions which are removed from the statutory purpose, and that's a fundamental administrative law principle.
My Lord, I don't demur from that at all. The point about the conditions or the ability to be given the licence is that one would have to be subject to whatever the board considers fit in carrying out its purpose. And one of the purposes is it shall not give you a licence if you haven't got the LCCA licence.
Yes.
And that incorporates to some extent the the objectives of the LCCA licence, because if you apply to the board, they say, well, go and get that licence and achieve the objectives of that. That interaction doesn't make a lot of sense if all you need is to pay some money and have this licence. Because we could give it to you anyway, not caring whether you're complying with the regulatory scheme that imposes the other conditions, or the other objectives, rather. So we do rely on the interaction. But the offence itself, I can just take the court to that. It's on page 1154, section 26. So it's B. Whoever carries on or attempts to carry on without a licence of trade or business which is required to be licensed under this law is guilty of an offence liable on conviction to a fine of $5,000 or to imprisonment for 12 months. It considers that to be of equal gravity to making a false or inaccurate representation to the board. Same offence, same statutory maximum, same imprisonable nature. Or carrying on in contravention of a condition or restriction contained in the licence.
What's the actus reus and mens rea?
There is only actus reus. There is no
Strict
mens rea,
liability.
apart from the willful. I leave aside A. It's B, which we're concerned with, is a strict liability offence. One has, if one's acting against the director, section 27, where the offence is committed by the body corporate, if you prove the consent or connivance or the neglect to which it's attributable on the part of the director, then the director is also liable. So there's obviously an element of mental consent or connivance, although there's also attributable neglect on the part of the director as the bottom threshold for the director committing the offence under section 27. But we're dealing with a company, the respondent's a company, so it's section 26, strict liability offence, you have committed. Now, I mentioned earlier the 2020.
Any case law, local case law in relation to convictions for that offence?
There's none before the court, and none I've specifically researched. It's not a point that's in issue, as it were, as to whether or not it's a strict liability. I think there was a prosecution, I forget under which act, which appears in the papers in terms of a newspaper. In any event, my lord, we rely on the reading of the statute that doesn't impose for a corporate body to commit the offence any mental element. The mental element is in the carrying on of the business.
And so under C, 26C, if a condition was imposed, for instance, that a company was to provide regular payments by bank deposit, by a standing order for the licence fee, and then omitted to pay the second one, or didn't provide the details, then that would be an offence.
Well, if it's a
The
condition,
contract would be void.
if it's a condition, if it's thought important enough to make a condition of the licence, then it's intended to be complied with. And if one doesn't comply, then that's more serious. My lord, although we're not dealing with the facts, I feel obliged to refer to the actual facts for the respondent, because the learned judge was very clear. This was a corporation who never applied for a licence despite being set up in order to conduct money lending, in order to hold mortgages, in order to loan money on 6 occasions to strangers, knowing the facts of what it was doing, having a prepared contract which it created, from which it made bespoke amends where necessary. The idea that this is just some form of unfortunate honest error, when one comes to proportionality, and we're nowhere near that stage yet, but when one comes to it, the reality is this was culpable behaviour, to be acting as a moneylender, someone who, I don't go into all the evidence if I can help because of time, but one has the evidence of the director, Mr. Barker, in the witness statement. He is somebody in the financial world. He's working in the USA on that behaviour. I can just find the reference. I'll take you to it. But one has an individual who knew at least enough to understand the risk that was being taken, but understood on the clear inference from the facts enough to know that he's acting as carrying on a business of lending money, and has done so without any licence or even application for a licence, despite having lawyers as company secretary, despite having lawyers retained to carry on transactions and managing the business thereafter. All of that is not an honest error by a business trying to conduct itself. And whilst we don't say the statutory effect of the purposes is all contracts are void, because that could work in justice if there is an innocent position, and particularly for the innocent party, but illegality is illegality. It falls to be considered in a nuanced way, but it is, the starting point is hit. You have committed an offence that Parliament has said warrants significant penalty. So we rely on the findings below that are not appealed as to the nature of the conduct at which Abarbanel was loaning out hundreds of thousands of dollars to 6 different individuals who were strangers, having been set up for the express purpose, for commercial purposes, carrying on a business as a moneylender. Around court 66 to 68. So we have, in this case, an individual making a loan at 16% or 18% in default at a time at which the rates were 0.5% Bank of England, secured against real property in Cayman Islands, which is supposed to be protected for a local population and local businesses by a licensing regime, but hasn't been protected. 360,000 or so has been repaid, but we are talking about the ability to obtain $1 million or so in interest, having acted illegally throughout all of the transactions, and despite at no stage even attempting to rectify your situation, if it was such a minor matter, and if you were then entitled to get a retrospective licence, which again brings control back to the board. So the board set up to control business on the islands in the public interest, we say, as well as revenue raising in the TBLA, but certainly in the LCCA as a control. We submit is a significant level of illegality and a significant matter to remain without licences, but seeking to enforce your illegal activities and asking the court to help you do that.
Would there have been any obvious problem about this person getting a licence, as far as we know?
We can't answer that.
No.
We can only point to the objectives and purposes of the statute, as expressed in the statute, and the fact there isn't a licence and there never has been.
But they're not a foreign company as such or anything of that kind?
But they are a foreign company. They're required to be licensed because, under the LCCA, because they're foreign owned. They're entirely foreign owned. Two Americans own the company. They don't qualify for exemption from control. There's no way around it. If you want to, in the situation the respondent's in, if you want to do business, carry on business on the islands, you must have a licence under both of these provisions. I mentioned the 2021 revision. Can I just give the page reference for that? So page 1176, we have section 18 of the 2021 edition of the TBLA. Broadly, a new version, I think, of section 16 about the granting of a licence.
Could I have the page number again, please?
Sorry, 1176, my lord.
Thank you.
This should be section 18 of the TBLA 2021. And it's one which introduces further provisions concerned with financial businesses and regulation of those financial services. So it cross-refers to section 182 of POCA as a person carrying on business in the regulated sector. That's at our page 1038, the POCA reference.
Sorry,
1038. And the regulated sector, construed in accordance with Schedule 4 of POCA, includes banking. It's page 1058. So you've got identification of individuals being part of it within the anti-money laundering. And then you've got the requirements for evidence. This is subsection DA, section 18.2 DA, page 1176. requires evidence of registration with a relevant supervisory authority where you are a designated non-financial business and profession. And then you have provisions in the statute from section 18 2E to GA, section 18 2E and GA of subsection 2, page 1178. Provision there for the Trade and Licensing Board to obtain information from public authorities, including the competent authority, which takes one through to POCA again. This time referring to section 2, it's at page 1166.
So whereabouts on 1178
So-
is the reference to POCA?
Reference to it's the reference to competent authority, which is defined at section 2 of this Act. You go back to 1166, I think you have the section 2 of this Act defines competent authority as the authority that POCA refers to at its section 2. That is
Which page is section 2?
1166, or the relevant competent authority is on 1166. Competent authority has the meaning given in section 2.1 of the
And what is the competent authority under section 2.1?
that is defined at page 921, section 2 of the Process of Crime Act. It means a public body in the islands charged with responsibility for combating money laundering and terrorist financing, including financial regulatory reporting authority.
That presumably is a remit extending well beyond POCA.
Yes, there are other anti-money laundering regulations and other matters.
So
But
then how do we know which authority it is, which responsible authority it is that's being referred to at page 1178? And where is the reference at page 1178?
That I think is the definition in section 2 of the TBLA Act. If I go back to our page 166. Competent authority has the meaning given in section 2.1 of
So why are you taking us to these revisions?
because we respectfully submit, inform the position as to what public policy objectives the regime fulfills. It's a regime which, in order to comply and have your licence, you must have the LCCA licence, thus importing the public policies there. You must also be someone who is acting in a way that is in consistency with the anti-money laundering and financial institution integrity objectives that the island has for public policy.
Even though these revisions were after the contract that we're concerned with, is that right?
Yes, because we're dealing with enforcement now of the contract or the charge. And so we say the public policy considerations.
Did the judge find that enforcement is carrying on business?
She finds that the respondent is carrying on business in the island.
She found that the respondent had carried on business rather than is now carrying on business.
Well, the pleadings, my lord, I see the respondent takes that point. The pleadings actually said you continue to be in breach of the law. So you are in breach of the law, you don't have a licence, you are still carrying on business in breach of the law. And the judge's findings are you are carrying on business, you've created these loans, carrying on business. It would not follow from anything that has been found as a fact that Abarbanel ceased to commit the offence when it ceased to have a licence at any time. The learned judge didn't have to deal with the continuation point because there was no argument about it. It never obtained the licence and never said it did. It only argued it wasn't carrying on business, which it was. And when she refers to it carrying on business, she refers to it enforcing and administering the loans.
I'm still puzzled at your emphasis on the reference to competent authority, because even if the amendments require consideration of money laundering and terrorist financing, there was no competent authority regulating the rates at which people lent money, was there? I mean, there isn't a loan shark, anti-loan shark regime in the Cayman Islands.
Well, there are anti-money laundering regulations in place, and it's been taking steps, of course, to remove itself as it did from the grey list and to deal with money laundering as a how do you define money laundering in that context? I mean, is charging an excessive rate of interest money laundering? I would have thought not. No, obtaining the benefit of your criminal conduct is money laundering, because the money laundering offences, in short, exist in POCA. That's part 5, I think it is, when we come to it, of POCA. So there are offences that are created by the bearing of a loan that pays you interest as a result of your illegal activity carrying on business. But those come up under POCA. But my lords, can I try to move away from the 2021 Act, because it is consuming of time when there are more, I think, important central points that I need to deal with in the next hour. Section 19 on page 1180 indicates about the granting of the licence in the 2007 Act. Sorry, we've moved now to the 2021 revision, but it's 19 1AB, my final point on this Act, is that 19.1AB on page 1180, shall not be renewed a licence if the applicant is not compliant with this Act or any other applicable law regulating the applicant, including laws relating to anti-money laundering. Now, to move on to the LCCA 2007, in force at the time, Control Act, a Companies Control Act, that also had a memorandum of objects and reasons, which was partly referred to in the Esso case. That is set out in the 1971 version on our page 852. And the beginning of the Act said, a law to prohibit, save under licence, the carrying on in the Cayman Islands of local businesses by companies which are not under Cayman control. That's the overall objective at its generality in 1971. The aim there is to prohibit carrying on of non-local businesses that aren't licensed. At the time, you can see on that page, it was the Cayman Protection Board would control the licensing. By Section 2 of the Act, if I move now to the 2007 version, on page 872, you have the board has now become, in Section 2.1, board means the board established under the Trade and Business Licensing Law. So an application for a licence under either would be administered by the same board. And the requirement that licence is set out there as well. But if I move forward to Section 4, this is set out on page 875. And we have there the requirement to hold a licence, subject to subsection 3, no company shall carry on business in the islands. So what is prohibited is carrying on business, unless it is empowered and B, it is licensed under this law and under the Trade and Business Licensing Law. So it's an offence if you're not under both, and at the relevant time is carrying on such business in accordance with the terms and conditions imposed in such licence and not otherwise. So it's clear as to what is prohibited. No company shall carry on business without meeting those criteria.
So would the correct legal advice have been to somebody contemplating carrying on business and obtaining a license, would the correct legal advice be that if you breached any term of your license, no matter how trivial, you put yourself at risk of all your contracts being held to be illegal, and you will have to go through the Patel against Mirza factors in order to make sure that those contracts freely entered into are enforceable. Would that be the correct legal advice?
Yes, and then you would be liable to rectification like ESSO did. So the board isn't expected to be unreasonable. It has chosen. Sorry.
So no matter how trivial a businessman is going to be advised, you're going to be at risk. Because
you are breaking the law. But of course, the reality is, if you break the law in an insignificant way, you can apply to the board to rectify your situation. There's no unreality to it's a law. If you break it, you're in breach. There may or may not be consequences that we can try and deal with. That's not bad advice. Don't break the law is the best advice. If you do break the law, we'll deal with the consequences, and the less insignificant it is, the more the law will have regard to that. There's no inconsistency in not having a binary position.
What impact would that have on the public good of the Cayman Islands, that you have that threat over the freedom to contract and the freedom to invest?
That you will know freely contracting as a Caymanian citizen, you are protected by the fact that they must comply with the licence they've been granted. And they must have a licence. And if they do neither of those things, you can go to the court and ask for protection because they've acted illegally. And the country knows that its system is not to be ignored. And that if you choose to do business there, you are obliged to understand the law, to obtain the licence, and to abide by it. It's not an unusual regulatory system, I respectfully submit, that you have a requirement to abide by it, rather than if it's a minor breach, it's not a breach. So the minority of it can be taken into account by the licensing board and by the authorities in any decisions about the consequences. But it also has consequences that you've acted illegally, which we're concerned with, of course, here. So
your argument's got quite dramatic consequences. I mean, say a company has a factory producing cars, and there's a piece of equipment in the factory which isn't fenced in accordance with the requirements of health and safety at work legislation. As I understand your argument, the consequence is that the company is carrying on its business in breach of a law which regulates its business. It's therefore liable to be unable to recover any amounts due to it, for example, on the sale of its cars on a Patel and Mirza footing, and anyone who pays it for the cars is liable to be guilty of a money laundering offence.
If a situation arises in which a company acts illegally and does not act to rectify that illegality, then it is subject to a consideration of what the consequences are of its illegality and profit it makes from it.
It sounds as though you're not disagreeing with the points I put to you.
My Lord, I didn't entirely follow what the precise circumstances are, but partly because we're concerned here with what the respondent did, and it's not. It's distracting from that point to look at all the permutations of an individual who might breach in another situation, because what we're not saying is every situation is under the same rule, because that's the respondent's case, that in every case you can't look at illegality. The appellant's case is the court is perfectly entitled to look at the precise consequences. The ESSO example, you look at the consequences, you look at what's happened before and after, and applying Patel and Mirza doesn't doesn't provide an inability to look at these facts specifically. It actually requires that circumstance to be considered. We say that's the benefit of common law illegality. The strength of it is that it does say we have a factor here, which is that the contracts have been entered into. All right, one party was unwittingly deceived that it was an illegal activity.
Well, can I stop you there and just ask you this question? Assume for 1 minute that the license holder is in breach of a license term and has entered into a contract with A. And A says, well, I want to pay you the money. Is A guilty of money laundering?
We're moving to...
Well, just looking at how absurd the construction would be and the need for the removal of all doubt. The Section 23 starts to remove doubt, which means, in effect, this legislation does not intend to make contracts unenforceable, but to make absolutely certain that we remove doubt. And what I'm testing it with is, why would somebody have to do that? Because of the potential for getting people, innocent people, convicted of money laundering offences, if your argument is correct.
My Lord, the problem is that that's one extreme, and you have the other extreme. If Parliament acts to exclude consideration of the illegality at all in relation to the civil contracts or transactions that have arisen from the illegality, then the opposite can occur, that you have someone profiting by $1 million, let's say, because that's this case, or illegal activities which have never been legal, have never been legalised, and on that basis are operating at a massive profit compared to any of the penalties that the regime itself has, excluding unenforceability or difficulties with prosecutions of individuals who are not on the island and other things,
Well,
or corporations.
Could you answer the question, would the person who paid in such circumstances be guilty of a money laundering offence?
If they have the mental state of knowing or suspecting that they are facilitating a criminal offence, that is money laundering.
Okay.
And that is a matter of statutory law, not a matter for interpretation, of course. But I don't think it helps with construing the 1971 intentions, because there wasn't money laundering law at the time. The construction of the legislation of Section 23, which I'm coming to as quickly as I can, is specific wording chosen against the extremes. And my Lord's putting to me the extreme that might be unfair to the consumer, who's innocent. There's also the unfairness that if it's always irrelevant, the illegality, equally a consumer can be unfairly treated. So those extremes must exist, and they must be known to Parliament to exist if it chooses to go down one route or the other. Our case is it hasn't gone down one route or the other, because it would be a very odd decision of Parliament to ensure that all illegal activity were condoned by reference to a statutory provision, Section 23. It just doesn't matter. That would be an extreme position to have taken, and there's no evidence that Parliament intended that position, and no absurdity to saying we won't make it automatically a consequence, we'll leave it to common law illegality, we'll leave it to a court to decide. So that essentially takes you to the Act and its wording. But we're looking at the offence section.
Perfectly rational to take the view that what Parliament, the purpose of Parliament is, it's not going to affect contracts. But of course, we're not ignoring the illegality. The illegality is dealt with by the criminal law, including POCA, if necessary. It's not a case of we're not interested in the illegality. It's a question of what is the impact of that illegality on what would otherwise be an enforceable contract.
Yes, and the option...
I think it's right to say that although there is this undercurrent that this is actually a bit of an extortionate loan agreement, your argument is equally applicable, as I understand it, however fair the contract terms actually are.
Yes, and once we arrive at Patel and Mirza, that's when it's relevant to look at the circumstances as to how fair or unfair the behaviour is, etc. Because that's when you're entitled to look at all of those matters. What is being put to me, I think, is that Section 23 should prevent the court getting to any of those matters in every case.
Yes, that is the good here.
Yes, And that's where I say, where is the evidence that that was a parliamentary intention, so that we are going to read it differently than the wording that's actually used?
Well, because if you look at the side note, it says effective infringement on business transactions. So the effect seems to be nil.
My Lord, the side note doesn't provide help on the question of whether it says something different to what it says about consequences. What it says about consequences is that it's not void or voidable. It doesn't say it's enforceable or not unenforceable. Now, I haven't come to those statutes bearing those meanings in the case law, specifically meaning what they say and being terms in a legal document that obviously convey the legal point. But we've skipped over section 11.4, which is about the purposes of the licensing. Can I just ensure that we've seen that even in briefly? Of course, the board may decline a licence on grounds of public interest without giving reasons. That's 11.1, page 879. I'll just invite attention back, please, to 879. We have section 11 as it's come over the page. On 879, section 11.1, board may in its discretion grant a licence, but if it's in the opinion it's not in the public interest, it may refuse without reasons. So clearly it's got public interest as a consideration. At 3, it may impose such terms and conditions as it sees fit to specify. If it couldn't, the licensing regime would be a yes or no. You can conduct business. They'd have no control over the public interest factors that might favour granting it on terms. And subsection 4 we submit is very important because it indicates the board shall have regard to certain matters. If those are statutorily relevant considerations, as they are, it's relevant to note what is made a consideration. The economic situation of the islands and the protection of persons already engaged in business in the islands. Public interest. Nature and previous conduct of the company and the persons. So a fitness of the person seeking the licence and its directors, shareholders or otherwise. It would be able to make inquiries into that. It should be told information about that. The advantage or disadvantage to the islands. The desirability of retaining control of the economic resources of the islands by Caymanians, including, no doubt, the real property situated there. Efforts made to obtain Caymanian participation, number of additional people outside, but then whether the company, its directors, employees have and are likely to continue to have the necessary professional, technical and other knowledge to carry on the business. Fit and proper person. Finances of the company and the economic feasibility of its plans. Very important if you're talking about a money lending business. How are you going to operate in a way that doesn't cause any difficulties? Whether the true ownership has been established. And then J, the environmental and social consequences. Couldn't be any clearer, we submit, indication that Parliament wants the board to control social consequences of businesses in the Cayman Islands. So
well, it can't do so internally. If you've got a Cayman company, it can carry on business in any way it wishes to, as far as money lending is concerned. How then could you possibly impose conditions on a foreign company to that effect? I mean, that would be just plain discrimination.
There is such discrimination, and it's lawful because the Caymanian purpose is to protect the Cayman Island population and economy. It is not to be fair to all citizens. So there are offences in here that a Caymanian citizen could commit, only a Caymanian citizen. There are offences that only a foreigner can commit. And so that distinction we submit is not discrimination, but has an objective justification to pursue the objective of protecting the Cayman population, such as Mr. Hawkins. So the island's interests, public interests, the population's interests are clearly factors statutorily to be considered by deciding whether to grant and on what terms. And the board can revoke a licence. On the next page, 881, 11.5, the board may at any time revoke a licence for a contravention of a condition, or if, in the opinion of the board, the company concerned is carrying on business in a manner detrimental to the public interest. This is the 2007 version. Or if the company fails to comply with a directive or requirement the board issues. So it's no mere formality to hold a licence. It is your entitlement to access the Caymanian economy and persons. And we can see the consequences of breaching that law. Already we saw it was an offence under section 4.2, breaching section 4.1, which is the carrying on of business.
Just before moving on, if the board revoked a licence and there were outstanding debts owed to the company that had entered into contracts with that licence, would the company now no longer be able to recover its debts? Because it would be carrying on business by seeking to recover the debts that were perfectly legitimately entered into, but now, by virtue of the fact it's got no licence, it would be prevented from recovering it.
It might depend on an argument about, well, you had a licence at the relevant time, because the words at the relevant time appear in section 23 and obviously in the offending. But one could have a consideration of the precise facts, but that isn't this case, because there was never a time at which it was lawful. So we don't have to concern ourselves with, are you carrying on business, or are you just, you've done your business and now it's the consequences of that are still available without Patel and Mirza, or they feature in Patel and Mirza anyway, because ultimately that was all conducted at a time when you were lawful.
Doesn't it raise the question as to whether or not revocation of a licence was meant to invalidate contracts?
We're not
invalidating the enforcement of contracts.
So that if you revoke the licence, you should still be able to carry on business, I think would not be right. So the definition of carrying on business is the point, and my Lord's positing an example where you might say, well, we don't want Patel and Mirza to come into play. We want to be able to say, well, actually, you were carrying on business at the time lawfully. You can finish that without carrying on business. But we're not into that definition. I certainly haven't prepared to deal with that case, because we have a company that was carrying on business illegally from the start to the finish, and at no stage even attempts to suggest it could have regularised its position. So we're not dealing with the minnows. There will be those examples. We're dealing with someone who knew full well that they were involving themselves in that position. And of course, if the licence is revoked, you have options of appealing that, challenging that, or obtaining a retrospective one once you've done whatever the problem was. But let's say your licence is revoked because you are a real threat to the public interest, to the social consequences in Cayman or other things. Obviously, the revocation of the licence is to end any carrying on of business, and it would have to have that effect to be of any use as a licensing regime. But Section 19 sets out these are not just breaches, they are actually offences. And if you don't pay your fine, you can be sent to prison. Perhaps less of a concern to a company, particularly a company where the fines are so minimal in relation to the profit from the crime. And Section 20, of course, deals with the director's position, which might arise. But to go to Section 23, as the court has already done, the wording is, no business transaction shall be void or voidable by reason only that, at the relevant time, in breach of the law. It doesn't exclude other reasons why a contract might be void or voidable, obviously. It doesn't exclude other reasons plus the breach, because it says only. So you might have a situation where a number of factors might, on established principles, lead to a contract being void. And it doesn't exclude it being relevant if the breach wasn't only at the relevant time, but continued. But that's one situation that might arise in which it wouldn't apply. So Section 23 could be read restrictively, being an exception to the consequences that would normally follow, could be read in a restrictive way in that way. But what is most important is that it doesn't require courts shall enforce the loans or enforce the could have said or unenforceable. It shall not be void, voidable or unenforceable. It doesn't say that, and it hasn't said that in any iteration since 2007, even if, and we don't accept that it's right, the respondent could say, well, things are more developed and understood now than they were in 1971. There were certainly cases, as we've demonstrated in, or can be seen clearly from the Halsbury's Jitty and other places, and in fact are referred to in Patel and Mirza as well, of cases where unenforceable was wording used, was consequences, particularly where it was unenforceable by one party, the guilty party, and not the other, at the time of the legislation being first enacted. So the first point to note about this, of course, is that it's not absurd to give it its literal meaning. This is what Parliament's written. It has a meaning, void or voidable. It has a purpose behind that meaning, which is that we shall not automatically prevent enforcement. And the lack of absurdity and the decision not to amend it to at any stage change that statutory wording indicates that it means what it says. The purpose of the statute is met. You are not free to carry on business without a licence, but it doesn't automatically unwind the transactions that there are, potentially to the detriment of the innocent, or potentially in a situation where the court considers it unjust overall, applying all public policy considerations to have that effect. So there's nothing, leaving aside whether it's correct to use Hansard in the way the respondent has, there's nothing in Hansard, there's nothing in anything that the respondent's pointed to which suggests that there was ever an intention on Parliament's side that we must exclude any consideration by a court of the merits of the consequences of the illegality, what has actually happened in the circumstances. And essentially, the court is being invited by the respondent to rewrite Parliament's legislation, change the words, or to add in not unenforceable. You have the Inco Corporation dicta at page 592 E to H of the in the bundle it's page 2260, but just this point that the court will be aware of. 2260, my lord.
2260.
In order to write in legislation like that, there has to be an error identified. So the court has to have a firm foundation for saying this legislation is not achieving the aim that must be behind it, and it's abundantly clear, by inadvertence, it fails to give effect to that purpose. This is a provision that works. It does what it says. It doesn't do more and it doesn't do less. We are not in a absurdity, needs to correct the error circumstance. Where Parliament must have meant, in no level of illegality, no matter how bad the example, perhaps worse than the respondent's even in that situation, even in the respondent's situation, no court should be entitled to consider the consequences of that illegal activity. And we then follow that with statutory interpretation of the words. You have the example of Chase Manhattan, Mr. Justice Knox, beginning at page 1870 of our bundle. And this is something the court will have seen from our written case. But that was a case where the Section 8.3 of the then Company Securities Insider Dealing Act 1985, you can see on the top of page 1895, read, no transaction is void or voidable by reason only that it was entered into in contravention of Section 1. the words void or voidable, same as the legislation we're looking at. Section 1, prohibited activity, you can see that on page, section 1 is set out on 1894, and the ingredients are analysed by the judge at 1898. It created an offence. And his lordship found that it did not follow that void or voidable meant Parliament intended the transaction wasn't to be regarded as illegal and to be able to deal with unenforceability under common law illegality. So page 1901A that's B. It does not, however, necessarily follow, because Parliament said no transaction is void or voidable by reason only of an infringement of Section 1. Therefore, such transaction is not to be regarded as illegal. The illegality is there by operation of the law. Provisions of Section 8.3 prevent what would otherwise be the consequences, that the transactions would be unwound. And his lordship finds that doesn't exclude unenforceability at common law. One goes to 1901E. Where Parliament desires to make a transaction unenforceable rather than void or voidable, it does so in terms. Compare this legislation. Section 63(1) of the Financial Services Act 1986. No contract to this section applies shall be void or unenforceable. As a result, at G, unenforceable and voidable contracts are different in many respects, and Parliament must be taken to have appreciated this. And below H, nevertheless I conclude, within the narrow field of refusing to lend the court's assistance at the suit of the person guilty of criminal conduct, there remains room for the application of the ex turpi causa doctrine, what we would now call common law illegality. And he decides over the page, the sale agreement is unenforceable. The statute says not void or voidable. Judge says, yes, that leads me to deal with the principles. I apply them to the result, it's unenforceable. Patel and Mirza in the Court of Appeal, you also have in the bundle, Lady Justice Gloucester dealt again with the wording of an act and whether void or unenforceable were the same or otherwise. And you can see that she refers to Mr. Justice Knox's decision. This is on our page 2454. At this point, the relevant legislation is now the 1993 Act. And at paragraph 68, Her Ladyship refers to section 63(2), no contract shall be void or unenforceable. By reason only of...
Can you give me the page again, sorry?
Sorry, 2454, my lord.
245. Thank you.
What you have on this page is the reference to section 63 set out, and then according to Gore Brown on companies, the Ladyship sets out the purpose of this provision. We've seen the intention behind the provision is to exclude the application of the common law doctrine of illegality. So by using unenforceable, that's the consequence. And at footnote 23 on the same page, you'll see the reference to Mr. Justice Knox dealing with a different parliamentary intention, which is just to make it not automatically void or voidable. It does not exclude common law illegality. You also have reference to that, again, in our case, paragraph 39A, page 606, we refer to this. There was a change in the Cayman Islands to the Insurance Act. That change affected in 2010. That's obviously an area where contracts need to be upheld. Insurance market long been held at common law before Patel and Mirza. insurance being as it is, needing to be upheld, and that Act makes provision in the Cayman Islands, Section 5 of the Insurance Act 2010, that an insurance contract, transaction, obligation or instrument entered into by any person shall not be rendered void or unenforceable merely because it's entered into by someone in contravention of Section 3.1, which is an unlicensed person. That decision, that section is referred to by Sir Anthony Smelly in Premier Assurance Group, which is set out beginning on page 1591 of the authorities. But essentially, the silence in Section 31 didn't prevent, of that Act, didn't prevent statutory illegality that rendered the transfer of business in breach void ab initio on the specific legislation there, also noting that change in the law. So applying statutory construction principles to the meaning of Section 23, there is no foundation for departing from the actual words used, which have a particular legal meaning and have had a particular legal meaning from the inception and from the continuation of the Act. It's not our case that it renders all unlawful acts void, of course, in all circumstances. Neither does it render them enforceable in all cases by the offender either. And only the clearest intention could exclude the court from considering the consequences of illegality and lead to an implied statutory prohibition on the common law illegality principles having any application at all, no matter the circumstances. A very different intent for Parliament to have to don't unwind it, to exclude the court's usual powers. And there are various cases on construction in the authorities. You have references there. You have Lord Hodges' dicta in the O case, paragraphs 29 to 31, in particular, may be of assistance. That's page 2907 of our bundle. With time pressing, can I move on to Patel and Mirza itself? This begins on page 2352 with the head note from the Supreme Court decision.
If it helps you, I think you can take it. We're all pretty familiar with this.
My Lord, it does help me. Can I perhaps just refer to a few of the paragraphs and, without asking you to read them, just make the point that I ask you to take from them in your reading, if that's acceptable. So, obviously, starting with the majority's judgment given by Lord Toulson in the leading judgment, one has there the fact that the court was faced with the Tinsley and Milligan principle of reliance as the doctrine's base, which had been the position for 2 decades or more, paragraph 20, page 2364. And my Lord Burrows is referenced in the academic context, paragraph 22, page 2365, with 5 policy rationales for the doctrine of illegality, which we submit respectfully support the appellant's case. We refer to those rationales, those 5 that my Lord indicates, that are given by Lord Toulson there, taking that from my Lord's work. So the 5 policy rationales, page 22. The consequences of statutory illegality and of nullifying are referred to at paragraph 40, page 2369, which is why it was rare for courts to find that implication. The consequences operating obviously against the innocent as well. If I go forward all the way through, obviously there's a very detailed look at various authority. At paragraph 82, page 2380, one has reference again to my Lord, but to the traditional maxims that perhaps don't greatly illuminate, but show that the basis for the doctrine of illegality. Ex turpi causa non oritur actio and pari delicto potior est conditio defendentis, set out there at paragraph 82 as traditional underpinning or reasons for the doctrine of illegality. And then we move through to possible range of factors at paragraph 93, again drawing on my Lord's work, page 2383. And then, as it was put, the future, paragraph 99, two main policy reasons for the defence of illegality, page 2384. Two main policy reasons for the defence of illegality. One is that a person should not be allowed to profit from his own wrongdoing. The other linked consideration is the law should be coherent and not self-defeating, condoning illegality by giving with the left hand what it takes with the right. Paragraph 101, page 2385, is the familiar trio. I'll come back to that in my wrap-up submissions on that point. The purpose of it, paragraph 102, with reference to the Hardy and the Motor Insurers Bureau case, 1964, Lord Diplock, or Lord Justice Diplock as he was, saying the rule of law on which the premise is based, ex terpi causa, is concerned not specifically with the lawfulness of contracts, but generally with the enforcement of rights by the courts, whether or not such rights have arisen under contract. And then at paragraph 107, there's the proportionality checklist referred to, given there's an infinite variety of cases which can be catered for by the common law principles. The three are set out. The court will be familiar with those. I'll deal with those in a moment in my submissions on this case. And you have the broad principle, paragraph 108, is not in doubt. Public interest requires that civil courts should not undermine the effectiveness of the criminal law. But there's an issue of interpretation of section 108, page 2386. We make this point about what his lordship was saying in our submission. He's not saying civil should leave it to the criminal courts just because the illegality is an offence. He's saying that confiscation, which is not a penalty that exists, can be with or without a conviction, 2386E. But the purpose of the illegality doctrine is not as a punishment, and it's not actually aimed directly at the justice between two parties. It's aimed at respect for the integrity of the justice system, is not enhanced by producing different results in a civil action than would be produced in a criminal offence. And at 109, his lordship set out that obviously one must abide by the terms of the statute, but the common law legality has regard to public policy factors in preserving the integrity of the law. The certainty of transactions point, his lordship deals with at 113, page 2387. Those considerations do not apply in the same way to people contemplating unlawful activity. And at 120, well, at 114, I'll just skip over, but at 114 he says people cannot be said to have entered into lawful transactions in reliance on the law acting unlawfully, as interpreted in Timsey. And 120, page 2389, the essential rationale of the illegality doctrine is it would be contrary to the public interest to enforce the claims. To do so would be harmful to the integrity of the legal system. And within that, within the trio framework, the court is not deciding a case in an undisciplined way. It's by a principled and transparent assessment of the considerations, not just broad discretion to be exercised Wednesday reasonably. It is an application of principle to be correctly given. That's, I think, the key paragraphs from Lord Torson. Then you also have other paragraphs we've referenced in the other speeches, the other judgments rather. Certainty or predictability of outcome. This is Lord Kerr at page 2394, paragraph 137. Certainty or predictability of outcome may be a laudable aim for those who seek the law's resolution of genuine honest disputes, not a premium for those engaged in disreputable conduct to claim automatic entitlement, which is part of the ex terpi causa point. And then at 143, page 2395, his lordship agrees with the traditional justifications for the doctrine of ex terpi causa maxima, preservation of the integrity of the legal system and preventing profit from wrongdoing.
Which was that paragraph?
Sorry, my lord, that is 143.
Fourth at
Page 2395.
Yes, indeed.
Lord Neuberger considered and then didn't adopt a general rule approach, but rather in the end agrees with Lord Toulson that the proper approach is to have this trio of considerations. And he talks about some matters of relevance. At paragraph 160, page 2399, difficulty seeing how a court could order specific performance of a contract which necessarily involved one or other parties committing a crime, even a minor crime. Paragraph 160, page 2399. And there is an issue there, of course, with specific performance, which we raise. And he, at 174 and 175, page 2402, agrees with Lord Toulson and finds at 175 it's not a discretion. He was persuaded that the approach is a principled way of approaching the circumstances of the case, according to the trio. And as far as relevant, also mention of Pocker, page 2404, 184, paragraph 184. Criminal law, the Proceeds of Crime Act, may inevitably have some impact on the rights and duties of parties who have entered into contracts with a legal connection. First point is not relevant. The second one is, insofar as the civil law is fashioned by judges in a particular case, they must ensure it's not inconsistent with the criminal law. And at 185, page 2405, where the civil court should not make any order or permit enforcement of an order if its effect would run counter to the provisions of Pocker.
So what paragraph?
Paragraph 185, page 2405.
Thank you.
And it didn't matter whether or not a criminal case is actually in effect or not. Obviously, that can't dictate the outcome. You could have a criminal case come or go during the course of civil judgment. So the point is about consistency, the integrity of the law as it stands, not about whether or not there is a particular prosecution or otherwise. Lord Mance mentioned also Pocker didn't have to be considered with in Patel and Mirza, page 2408, paragraph 198. Now, there have been a number of cases since then which are of some relevance and importance. We say that there's much to commend Lord Justice Underhill's judgment in Okadina, the 2019 Court of Appeal case, which is at our page 2535, particularly on the statutory interpretation, the need for a clear or necessary inference, etc., paragraph 20, page 2541. And the bluntness of the weapon that is statutory illegality, paragraph 49, page 2549. And then Lord Hamblin's judgment in Henderson and Dorset Healthcare, which I suspect the court has seen much of in terms of its recent workload, but that's the diminished responsibility negligence claim by the killer who suffered or committed the manslaughter by diminished responsibility. But in that case, his lordship looked at Patel and Mirza and gave some useful guidance about its application and the way in which the courts can approach it. If I skip through to what his lordship said at 116, I think it should be my starting point, page 2248. 2248.
248, thank you.
Paragraph 115 said that the policy consideration should be capable of being addressed as a matter of argument. Didn't need evidence to decide the trio policy considerations. It's a matter of policy, matter of argument, 115. 116, he describes the three stages to the approach. Stage A and B are to look at the converse competing public policy objectives. And stage A, paragraph 119, page 2248, should not be interpreted as being confined to the specific purpose of the prohibition transgressed. And he went on to talk about preventing someone from profiting from his own wrong is not the rationale for the illegality defence, but it's a relevant policy consideration linked to the need for consistency and coherence in the law. For one branch of the law to enable a person to profit from behaviour which another branch of the law treats as criminal or otherwise unlawful would tend to produce inconsistency and disharmony in the law and cause damage to the integrity of the system. It too is a factor to be taken into account. At 120, the relevance of the reliance that is placed, the closeness of the connection between the claim and the illegal act, and the danger that poses to the integrity of the legal system. It's not the test for illegality, but again, a relevant factor. And at 121, he considered that great weight should be given where they arise to the factors that, page 2249, paragraph 121, a person should not be allowed to profit from his own wrongdoing and the law should be coherent. Great weight for those. And he then talks about the disproportionality check rather than a proportionality requirement, paragraph 123. And at 124, suggested that centrality of the illegality will often be a factor to particular importance. Whether there's a causal link between the illegality and the claim, and the closeness of that will often be important considerations. And the thrust of what his lordship is saying is, it's not the ground zero for Patel and Mirza. These principles are given effect to considering the trio of considerations, and they all still have that approach. Another case you have in the bundle is Stoffel and Grondona, in which I know some of my lords sat. That's at our page 2026 onwards. And again, it deals with the question of profit from an illegal scheme and profit from our own wrongdoing, and issues with specific performance being ordered, being contrary to the integrity of the legal system. You have some authorities that my learned friend refers to in the bundle, in which he submits that the Chancellor, Sir Geoffrey Voss, has introduced a Wednesbury approach rather to this court or any appellate court in a Patel and Mirza case. With respect, that hasn't found favour in any of the higher authorities that have looked at this. This court has not approached in that way, and there are three reasons why that's wrong in any event. Firstly, Baroness Hale specifically didn't approve of it in the Supreme Court in that case, Singularis, her page 21. That's not in the bundle, but she recorded her reservations about that. It's not akin to exercising a discretion, Patel and Mirza, it's principles application. Number two, it's entirely, as I said, absent from higher authorities. And thirdly, it was based on proportionality, and as this court knows, the approach of appellate courts to proportionality is much more nuanced than saying that it's a Wednesbury test in all cases. This court's judgment, of course, in Shivler and Dalston projects being an example of considering that point, which has arisen many times since these cases of Sir Geoffrey Voss. So we don't submit that's the right way to address it. The e-banks, I'm conscious of time, so I'm taking things at rather speed. The SO case, of course, predates Pocker and predates Patel and Mirza, but also the Section 11 changes that were made, which we've pointed out. And in fact, we read Justice of Appeal George's as not saying Section 23 ousted common law enforceability. In fact, it goes on to apply common law enforceability, illegality rather, despite the view that Section 23 would weigh heavily against it applying. They didn't find it as an ouster. I appreciate the Court of Appeal below may move more in that direction, but SO, close reading of that, did not say that it was unenforceable, or the legislation precluded that. So far as the Court of Appeal is concerned, it obviously addresses common law illegality in just 3 paragraphs, and we say it does make an error in any event because it's heavily relying on the suggestion that essentially it cannot be looking at it, doesn't go on to deal with those matters properly. So far as the respondent's point on knowledge, there's this distinction, as I said at the outset, between facts and law in terms of knowledge. Abarbanel at all times had knowledge of its conduct, which was the carrying on of business that the judge found. Ignorance of the law is no justification, nor indeed is there any evidence that Abarbanel was ignorant of the law. There's nothing in its evidence, quite conspicuously, about why it didn't have a licence. It just denied that it was carrying on business and therefore wasn't in breach for not having a licence. But there was the statement, as I said, of the director is at page 284 of the bundle onwards, paragraphs 5 and 6, and 18 and 19. We submit respectfully go to undermining any suggestion that this is someone who would have a genuine ignorance of the law. Certainly wasn't ignorant of the facts. And we've said, we've pointed to the case of Bonnard and Dott and others where essentially if you are lending money, it's your obligation to make sure you're complying with any rules that apply to lending money. It's an area of transactions which are clearly known to be carefully regulated in the public interest, no matter how well or light touch regulated. Certainly the idea of doing business in that way, unregulated, would be a surprising proposition for anyone in that business world, as Mr. Barker was. So far as application of Patel and Mirza in this case, the task of the court, of course, is to consider whether it is contrary to the public interest to enforce, because it would be harmful to the integrity of the legal system. That's the ultimate question, the rationale for the doctrine. And our first point is that is in the... So firstly, the considerations as to why we support the purposes of the legislation and the illegality being deterred and being dealt with. Firstly, profiting from your own wrong. I've dealt with a very high level of profit and the inadequate penalties. Avoiding high profits from crime, referred to in the Yango pastoral case, for example. And there's no unjust enrichment. So first, preventing profiting from his own wrong. Secondly, the need for consistency and coherence in the law. We've just seen that they are to be given great weight, according to Lord Hamblin. We respectfully invite the court to give great weight to them. They are the two policies behind the illegality doctrine entirely, and they give an outcome where public policy is not advanced by an innocent party having a contract enforced against them, where the ex turpi causa doctrine and its rationale is about not allowing those who commit the facts which are illegal from benefiting from that. The third point you have is POCA, not compelling a crime by the innocent appellant to comply. Closeness of the connection, fourthly, between the claim and the illegal act. We say it's a reliance case, a centrality case, and as Lord Hamblin says, that's again a factor that goes against enforcement. Fifthly, you have imbalance of parties' positions. The regulation required by the law, the objective of that regulation is further by illegality being recognised.
What was your fourth point?
Fourth point, my lord, was the closeness of the connection, the centrality of essentially reliance. Of course, you're saying it's that business I conducted illegally which I rely upon in order to found my claim. Relevant factor, not the test, I appreciate all of that, but relevant factor. Fifth was the imbalance. The good faith that a borrower could have is not furthered by allowing the illegality to be recognised. Sixth is the context of money lending, as we've mentioned, is a specific context that the court has always been cognizant of when looking at transactions in that field. And I mentioned already the various statutory provisions that relate to that. Seventh, the importance of the regulatory scheme being upheld is reflected in the existence of offences for the breach. So it was of significant importance to the legislature to make sure it's enforced, that there are offences, but those offences don't, in this case, of course, provide a complete deterrent or a complete answer to it. That they are the same underlying purpose, that there is to be the protection of the public as a public policy by these licensing regimes. And the extent of the offending, of course, with Abarbanel extends beyond making the contract. It's carrying on the business entirely, taking the security, administering the loan, collecting the interest, and steps to enforce. Each of those committing, again, the TBLA and the LCCA offence that the judge found it had committed because it was carrying a business without a licence. And we point again to the fact it was pleaded as a continuing one, and the judge didn't have to go any further than find you are in breach. The purpose of the statutes is enhanced by not allowing it, because firstly, companies would have a strong incentive to apply for the licence and obtain and adhere to it. Secondly, companies that couldn't obtain or were unwilling to apply for a licence, if they carried on business in the hope of avoiding detection, would face immediate real consequences. And deterrence in circumstances such as this, with high profits at stake, the continued control by the board, the protection of the public interest referenced section 11.4, and the protection of revenue, and the protection of the legitimate businesses in the Cayman Islands.
Mr. Rule, we're some minutes now past half past.
Of that. Those submissions we say place in the balance the Patel and Mirza trio and, of course, when one's looking at the proportionality of matters as the check, the third point, the core policy concerns can be repeated there as to the seriousness of the conduct in relation to it, the repeats of that offending, the nature of it, and the specific way in which the business was being carried out. On the other hand, the fact that the appellant wasn't aware of the illegality and wasn't party to it. We respectfully like the court not to find as a check balance that it is proportionate to allow this illegality to result in such heavy profit. That obviously runs me out of time without touching on two elements of the case.
We have a very full written case from both parties.
You do. My Lord, in fairness to the POCA matter, the three elements, I said right at the beginning what those three elements are we rely upon. We do submit they're pleaded. I know the respondent's case doesn't really deal with my case as pleaded, but we say it's relevant on those three particular points.
Yes, if you want to use some of your reply time, I mean, it's a matter for you. We can allow you to do that if you want to develop this further as part of your principal argument.
My Lord, I'd be grateful. I think I'll do that. If I could take
if you're going to do that, then do address us on the question whether we should hear you on this point at all. Very well. We'll adjourn then for the moment and resume at about 2:30.